The rights and equitable treatment of shareholders and key ownership functions. 1. Small reminder. What is a shareholder? Same risks and same treatment. To what extent? 2. Rights of the shareholders. Some basic rights, additional rights distinction, ex ante/ex post rights. Rights of the shareholders protected by the law. 3. Limits in shareholders' power. Limit in the exercise of the corporate activities. Limit in the abusive exercise of the rights safe harbors. Shareholder rights. Secure methods of ownership registration, convey or transfer shares, obtain information on the corporation on a timely and regular basis, participate and vote in general shareholder meetings, elect and remove members of the board, share in the profits of the corporation. Shareholders should be informed and have the right to participate in decisions concerning fundamental corporate changes, amendments to the statutes, or articles of incorporation or similar governing documents of company, the authorization of additional shares, extraordinary transactions. 1 and 2. Shareholders should have the opportunity to participate effectively and vote in general shareholder meetings and should be informed of the rules, including the voting procedures that govern general shareholder meetings. Sufficient and timely information, equitable treatment of all shareholders. Potential obstacles, charges, fees for voting, prohibitions on proxy voting, personal attendance, holding the meeting in a remote location, voting by show of hands. Voting materials may be sent too close to the time of general shareholder meetings. Section C3 and 4. 3. Shareholders should be able to ask questions concerning external audit, place items on the agenda of general meetings, propose resolutions subject to limitations. 4. Effective shareholder participation, remuneration of the managers and board members, disclosure of candidates, personal info, all compensation agreements. 5. Shareholders should be able to vote in person or in absentia, electronic voting, proxies, disclosure of exercise of the undirected proxies. 6. Impediments to cross-border voting should be eliminated. Foreign investors through intermediaries. Shareholders, including institutional shareholders, should be allowed to consult with each other on issues concerning their basic shareholder rights as defined in the principles, subject to exceptions to prevent abuse. If small shareholders did invest resources in such activities, others would also gain without having contributed, that is, they are free riders. Institutional investors are prevented from doing this because it is beyond their capacity or would require investing more of their assets in one company than may be prudent. To overcome this asymmetry, cooperate and coordinate their actions in nominating and electing board members, placing proposals on the agenda and holding discussions directly with a company, communicate with each other without having to comply with the formalities of proxy solicitation. Equal treatment to same series of a class. Within any series of a class, all shares should carry the same rights. Decisions about negatively affected investors should be taken with respect to their approval. Shareholders should be informed about preferred stocks. Lower share price may mean limited or no voting right. Proposals to change the voting rights of different series of shares should be accepted by only majority of voting shares in the affected categories. The disclosure of capital structures and control arrangements should be required. Some capital structures may allow to multiple or limited voting rights. Small shares may constitute effective majority. There might be some agreements such as not to sell shares within specified duration or purchasing preferential shares barely. Regardless of the number of shares, if voting rights of shareholders might be limited. Disclosure of above capital structures and control arrangements allows shareholders and potential investors to make better informed decisions. The procedures for approval of related party transactions ensures proper management of conflict of interest, protects the interest of the company and its shareholders. On conflicts of interest inherent in related party transactions, abuse procedures, board approval, shareholders. 2. Having a material interest in any transaction, business, family, or special relationship, material interest. Minority shareholders should be protected from abusive actions by or in the interest of controlling shareholders acting either directly or indirectly and should have effective means of redress. Abusive self-dealing should be prohibited. Markets for corporate control should be allowed to function in an efficient and transparent manner.